Hi, it's Monday, and that means another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about football and concussions. Cases that should have gone to the Supreme Court of Canada, but didn't. Arland Bruce was a football player for the BC Lions and the Montreal Alouettes, and unfortunately, over the course of his career playing professional Canadian football, he sustained a number of head injuries, concussions, and ultimately that left him unable to work. Mr. Bruce sued the BC Lions and the Canadian Football League, arguing that they had breached their duty to him as an employer to protect him, but also that they had breached their duty to warn him about the dangers of playing football and the associated concussions. The court dismissed Mr. Bruce's claim and actually struck his claim from the court in its entirety, saying that what he had to do in order to advance his claim was go through an internal grievance and arbitration process with the Canadian Football League. This, unfortunately, was not something that Mr. Bruce wanted to do. He appealed the striking of his claim, that was dismissed, and he sought leave to the Supreme Court of Canada, who denied the claim. But why did they deny the claim? This is a more important issue than just a simple labor and arbitration dispute. This has to do with a more significant issue to Canadians, which is how much your employer has to warn you about the dangers of doing your job, and how informed you need to be before deciding whether to take a job and whether to stay at that job when the job exposes you to dangerous conditions like football and concussions. And because research and science on concussions is developing so much more now than it has in the past 50 years, and because so much more attention is being paid not just nationally, but internationally to professional sports and concussions, shouldn't the Supreme Court of Canada have said, wait a minute, this is a case that is bigger than the labor and arbitration system that's set up with the CFL. And why should people who are part of a bigger movement and part of a bigger significant issue with respect to employment law generally have to bring their claim solely within a labor and arbitration system that isn't equipped to deal with those issues? This goes back to issues of competing statutes that we've talked about in previous videos, and also the purposes for which some forums serve and some don't. The Supreme Court of Canada could have allowed Mr. Bruce's claim to proceed and could have allowed the remedy that he needed, or at least provided guidance to people moving forward with their concussion lawsuits, whether they're in the labor and arbitration process or outside that process. By striking the claim and leaving Mr. Bruce as he was left without a remedy and left without any compensation for injuries that were caused to him as a result of his profession. And while some might say, I don't know, you're playing a high-contact sport, you should expect to be injured, that's not enough. The Supreme Court of Canada had an opportunity here to get in on a very important issue that affects people worldwide. They had an opportunity to create good precedent that could be used not just in Canada, but throughout the world. And unfortunately, they failed to do so. This is a case that's going to have to wait for another day, and one day we will see a concussion case at the Supreme Court of Canada. It's just not going to be that of Mr. Bruce. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but Didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but Didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative has been invaluable in putting together these videos, and I encourage you to like, share, follow, and tune in next week for another episode.